Welcome to our podcast on Can Trustworthy AI Help De Risk Adoption of AI? This episode is on responsible use cases in legal AI. I'm honored to be talking with Dr. Megan Ma. Megan is a fellow and the assistant director of the Stanford Program in Law, Science, and Technology and the Stanford Center for Legal Informatics. It's called Codex. Her research focuses on the translation of legal knowledge to code, considering its implications in context of human machine interactions. And Megan also teaches courses in computational law and the insurance tech at law school. Megan, welcome to the show. Very happy to have you here.
Yeah, pleasure to be here. And thank you so much for the invitation, Pamela.
Thank you. And in addition to the introduction, I think I want to mention one more thing that you're also the managing editor of the MIT Computational Law Report. So, definitely very interested in talking to you about the responsible AI and responsible use cases and having this conversation with you. So, let me ask you since our focus for this podcast is can trustworthy AI or responsible AI be instrumental in helping organizations adopt these foundational at the foundation adopt these practices to not only de-risk their adoption of AI but also to gain a competitive edge and promote better business outcomes. So let me ask you at the beginning, at the very outset, a couple of questions that will help us understand uh, what you are doing. So, if you can give maybe a description of what is your role and your focus.
Yes, absolutely. So, as you kind of rightfully pointed, I'm the assistant director at the Stanford Center for Legal Informatics. I also wear the hat as the assistant director in the law school's Law Science and Technology program. And basically, what that really entails is we often work with industry partners to try to understand how do we actually prepare our law students for the coming age of generative AI or any other kind of technologies, or kind of how these emerging trends are influencing the legal market. A lot of kind of what we've started to do actually at the research center side, so at the codex side, is we started to think about how do you actually build technology for law. And quite often, I think when we investigate and look into the legal system, we notice that it is quite inaccessible in many ways. There's statistics that are horrifying of 70-80% of people that don't have access to lawyers, even though we kind of have such a vibrant legal community. So, why is that the case, right? So, a lot of our research is how do we actually leverage technology to kind of alleviate some of the pain points in the legal system? The flip side of it, though, is that what people are seeing with generative AI is a whole slew of risks that are actually not always new, but that have resurfaced and almost accelerated kind of in light of these new developments. And so, how do you sort of reconcile what's existing structural questions in the legal industry, in the legal environment, with kind of these new technologies? And what is their actual realistic impact? And so, that's quite a bit about the work that we currently do at our center. Um, and so, some of the things that we've started to explore is actually how do you develop tools that actually will help train future lawyers, and how can we actually make the best use and think about as well what are the potential harms associated with these types of uses.
That's pretty amazing. And I think from what I'm hearing, since I'm coming more from the business world, is that there may be some parallels and adaptation of what you're doing for a broader community. What are your thoughts on that?
Yes, so actually, we frequently work directly with, say, law firms, other companies such as insurance, and they
Okay.
kind of come forward with almost their challenges that they are seeing. For example, some law firms are coming to us and saying, can you help us imagine, like, what does it take to be a partner 20 years from now? Is there something that we are lacking currently internally at the law firm to best prepare our young lawyers? And, we often kind of joke around about how when first year associates or the first year that young lawyers fresh out of law school, bright eyed and bushy tailed, enter into legal practice, why is it that they're incredibly smart and talented, but they really struggle with actually trying to understand these industry nuances? And so, what we're noticing is that historically, there's always been a gap between law school and actual practice. And so, how can we think about technology as a way to kind of bridge some of this gap and kind of help minimize that ramp up time that's required for these young lawyers to actually really start bringing and generating value for these firms? And so that's some of the things that we think about as a research center and as a law school broadly is, what are these new transformative techniques that are required to actually get people to think in advance what it's like to be in practice while they're still in school?
Wow. And as you're talking, the light bulbs going off in my mind, because as I was noting earlier, that I do see some parallels, and this is a perfect in my world way of describing a mentorship, right? As a new associate joins a company, for example, and it could be in even in things such as critical infrastructure, for example, how to kind of prepare and how this can really help in terms of using technology to help them ramp up to what they need, fill in the gaps for where they need to be. That's amazing.
Yes, exactly. So, oftentimes, exactly to your point, that there is strong mentorship models that are in place. But as a young lawyer or as a young associate, sometimes you don't even know what you don't know.
What you
And
don't
so,
know.
a lot of these one on one mentorship sessions, the fear is that I'm not asking the right questions and I'm not
Mhm.
making the most out of these sessions with a partner. And so, what we're trying to do is, can we actually almost preview in advance or kind of use technology to almost grasp the brains of our partners, be able to kind of provide a glimpse of their experience and what they've learned in their experience, and kind of feed that into a young lawyer and a young associate? And so we're using actually generative AI to think about, can we build almost like a digital twin in a way of a partner, and kind of actually have an associate go through a simulation of what it's like to see or, you know, edit or draft contracts in the eyes of that partner. And so those are the types of kind of future looking technologies or future looking uses of generative AI that we think could be incredibly powerful from this training perspective.
Okay, well, that's I have two questions related to that. One is a comment, right? Which is, one is, in the beginning you'd mentioned that there is a well, firstly, let me ask you this: for contracts, is that something that is a time consuming process? That can you talk a little bit about that? How long does it take, for example, to somebody to really excel or even understand what needs to be done there? And is that a challenge that is being solved by this, for example?
Yes, so there's quite a few actually technologies right now. It's a part of kind of, the age old saying, you have to do the grunt work before you can start doing some higher order analytical tasks. And, young lawyers often complain and they're sort of almost disillusioned that they come out of law school and they think they're going to be, in the courts and doing really incredible work in the legal space, but really what they're doing is just reviewing contracts over and over, or they're copying pasting from precedent language. This is starting to change a little bit given the fact that, legal tech has been around for a while now. And so to your point, it's actually still fairly an inefficient process. But really here, what we're kind of looking into is at different sort of stages as a lawyer, whether you go from a junior associate to then a senior associate and then a partner, you're starting to issue spot or identify problems or flag risks in a contract differently. As a junior associate, I may not know what to look for at all. But as
Okay.
the years go by, and as, failure is the greatest teacher in a sense, you start to
Mhm.
know what I should be looking for. And so, to my point earlier about developing tools that kind of could see through the lens of a partner, what we're really talking about here is, can I review a contract as a young lawyer, turn on a particular mode, and be able to see actually relative to how I've edited the contract or reviewed the contract, how does a partner compare? And then I can tell immediately before I even approach the partner some of the discrepancies that I'm already noticing. And if there are concerns there that, I didn't really understand why this is the way that you've issue spotted in comparison to how I've done it, then I can ask a more pointed question in a way during my mentorship session. Say, in an M&A contract, you notice that the partner that you're receiving mentorship with, they are constantly picking out certain things. But you want to dive deeper as to why they constantly choose this particular thing to flag as a
Okay.
risk over another. Then you have a more focused kind of mentorship model here. And it's not just, I'm having trouble with contracts generally, or I'm having trouble with this type of contract. Instead, you're saying, I'm having trouble understanding these clauses, particularly how they operate in this circumstance. That is a much more precise and actually valuable, I think, approach to the way you're training your lawyers.
Yes, and very personalized, right?
Mhm.
That is the one of the main highlights and advantages that are there and that we are hoping to achieve
Mhm.
with AI is that personalization aspect of it, right? So this takes learning and becoming adept and really mastering it to a different height completely. Yeah, thank you. Thanks for sharing that. Um, can we talk a little bit about the MIT Force, task force, responsible AI that you're leading also, Megan, in terms of how would some of the responsible AI characteristics influence what is what you're doing, what you are um, uh, crafting in terms of response, not responses per se, but strategies or approaches, for example, when it for even for crafting the generative AI use case that you mentioned.
Yes, absolutely. So, the MIT Task Force on Responsible Uses of Generative AI, specific to the legal profession, it came as an offshoot of realizing kind of not only how powerful these technologies can be, but also kind of thinking about what are the implications and the historical role as lawyers who are frequently advising on how do you hedge risks in certain situations. And we do that through contracts and other types of legal documents. And then, not too long after the task force and I, so it's sort of co led between MIT and also with Stanford Codex as well. Um,
Okay.
some of our task force members, including Daza Greenwood, him and I kind of started to read the news about the New York Times famous case Mata versus Avianca, where the lawyer had used ChatGPT to draft the legal brief. And suddenly the entire world started to look at lawyers. Oh, they're using ChatGPT as well and kind of, irresponsibly. And so it became
Mm,
more important than ever for our profession to say, you know, we actually take a lot of seriousness to the way that we think about using these technologies. And this is a particular sort of exception to an extent that, these technologies were viewed as somehow truth tellers in a way, which, if you understand the kind of foundation of these technologies, you'll notice that you will not get absolute accuracy and absolute reliability and consistency using these models. And simply because they're built on statistical and probabilistic foundations.
right.
And so for us, we started to think about what are some of the existing rules and professional rules of conduct, and how do they kind of interact with this new technology? And what we started to notice actually is that the principles that we've come up with, and there are sort of seven key ones, I'll perhaps highlight sort of three: the duty of confidentiality, um, the duty of disclosure, and I'll go back to that one, and the third one around duty of competency. And a lot of these actually mirror to an extent the American Bar Association, the ABA's model rules of conduct. And what was fascinating is that we were incredibly lucky that the State Bar of California actually took notice of these responsible principles that we put out and actually had sort of adopted them into their practical guidance, which was released mid November this year.
Wow.
And what really within the state of California, they now kind of strongly advise actually all lawyers that to uphold kind of professional responsibility, you should kind of be working consistently with their practical guidance, which then draws from our MIT task force's responsible principles. And so, going back to kind of the specifics of these principles, the duty of confidentiality that has never changed. We have, as attorneys, like the responsibility to protect the information that is disclosed to us by our clients. The one that I think is an area that is particularly concerning, I guess, in light of these technologies is a lot of kind of the data privacy, data storage associated with using kind of vendors or proprietary models, such as ones from OpenAI or Anthropic. Um, they've already started to mitigate some of those risks. They say that if they work with enterprises, you'll have your own kind of instance such that you wouldn't have these kinds of fears around kind of data leakage. But
Right.
the issue is that there's still kind of prompt injection that can happen that is like kind of appending sort of certain strings. We've seen that in papers and research released on universal and adversarial attacks on these models. And so how do you sort of mitigate for those? And we've often seen, the discussion around should we use open source models then? But the problem is that lawyers then are very careful about how well these models can perform. And simply at the moment, there is a general distrust for open source models, even though they're starting to become increasingly kind of well performing. Um, the other thing that has been interesting is this discussion on the duty of disclosure. So, how far back do we actually, as lawyers, have to share that we used generative AI tools? And it's becoming increasingly difficult to sort of describe that. And the reason being is because obviously Microsoft through Azure, they have Copilot. Those tools are sort of natively integrated at this point. And you also have that with Google Workspace. You'll have that kind of upon the release of Google Gemini. And then you also, on the other hand, you're starting to kind of see, the big names like Thomson Reuters with Westlaw and kind of LexisNexis, all of these have their own generative AI capabilities. And so, in saying, oh, I'm using Westlaw, is that
Mhm.
enough of a disclosure?
Right.
So right now, there's been, at the end of the day, serious behavioral uncertainty, as I like to describe it, on lawyers' comfortability in using these tools. And I think at the end of the day, there's going to be increasing sort of private governance on how kind of the uses of these tools will naturally kind of play out in the work products that lawyers produce. But I think at this stage, a lot of what we think about when you discuss sort of de risking or responsible uses, what are some use cases right now that we can think about that don't necessarily depend on paradigms of accuracy, that we have to have the right cases all the time, and instead are more of a behavioral focus? So we can help, at least move our lawyers and get them better equipped and better, more comfortable with this technology in general. Some of that behavioral uncertainty comes from this general idea that, I'm not 100% certain about how I even should be using these tools. And so,
Mm.
as long as we kind of build almost lower risk use cases, such as those of training, as I mentioned, we often kind of simulate how partners edit contracts. That's a great sort of way that doesn't necessarily have client or stakeholder implications. It's an internal tool that's going to help kind of more efficiently train your lawyers. The other side that the other project that we're doing is we're almost doing contract negotiation and litigation negotiation, sort of litigation strategy type simulations. And what we mean by that is we're trying to build almost tools, almost if you can imagine like a fighter pilot where they go into a pilot simulation and have to fly a couple rounds using a machine versus a real plane. We're going to get the young lawyers to pilot an M&A negotiation well in advance so that when they actually have to deal with a client, they already sort of know in advance what are the types of questions they should be asking. So, again, these are tools that are within the space of education and training that, in a sense, are lower stakes because they're sort of mirroring the specific practice of a law firm, of an organization, as opposed to kind of the end uses, which is has client and stakeholder implications. And particularly judges are sensitive at this point still about, them producing precedent that is just not real. And that was the case not only with the Mata case, but also in Colorado, where a young lawyer had actually cited fake cases, but
Yeah.
caught himself in advance and disclosed to the judge. And that was still kind of viewed as problematic. And so that's sort of how we see risk mitigation as how do you kind of leverage actually these unique capabilities of generative AI, which actually comes very powerfully from a narrative perspective. They're great at writing really eloquent passages at times. And I think that
Right.
it's excellent sort of writing or storytelling abilities. They make for great sort of teaching tools.
Yeah, thank you. I agree with a lot. I mean, I have a lot of observations, comments, feedback on, because you've shared a lot. And this is really very interesting because, like, I keep drawing parallels in the business world for what you are talking and, bringing to us. It's really fascinating. Um, so a couple of areas that I kind of wanted to let me see how we're doing for time too. A couple of areas that I really want to kind of drill in on a little bit, at least given the time, is the clause for confidentiality first, right? One thing that is extremely commonly that and even I'm advising clients on is to have their own to do adopt RAG, for example, and use their own data for fine tuning their
Right.
LLMs so that they can um, get the desired outcomes and value for business. And one of the pillars that I had mentioned, that I had defined, pillars for de risking AI adoption, has been at the very foundation level that any implementation, even if it's not a very high stake implementation, to have security and privacy at the very foundation. You'd mentioned two things that I think really kind of reiterate my messaging as well, Megan, which is fantastic to kind of share these thoughts. And that's on prompt injection and adversarial AI, right? So I think, in fact, I'd like to mention just yesterday I was at a NIST hearing for emerging technologies, and one of the things I mentioned is the security risk around AI is not that well understood right now. Even in the security community, there is a lot of propensity to adopt and think of security is going to be the same for AI as it has been for other technologies and systems. But there are so many differences that can be very, very critical and high impact for us as users and affected, individuals directly or indirectly for whoever is adopting these. So that is a very, very interesting conversation about the three clauses that you mentioned for confidentiality, disclosure, and also for competency. One thing also I wanted to talk about was disclosure. What are your thoughts on, yes, in the whole ecosystem? You mentioned Westlaw. If you are a agency, a law agency or a law firm, you are doing you're subscribing to third parties that are providing information, such as the one that you mentioned. And if they are using generative AI and they are telling you they are using generative AI, but how effective is that for you to? realize that this may not be all factual. For example, right, there may be some things that are, because there are troves and troves of data, right? There's
Mhm.
so much data, especially in the legal field. There's a lot of data that you're looking at, um, that even if there is something that is introduced which may not be completely accurate,
Mhm.
it's going to be hard to detect. And if it's coming from a third party, for example, service that you're subscribing to, even knowing that they are using generative AI, what are your thoughts on, how do you combat that risk? Because that is a risk.
Mhm. I mean, that's a fantastic question. And truthfully, that's one that the task force we've struggled with. It actually took us several meetings to even wrap our heads around disclosure because disclosure sort of has a mirror, which is consent. And the idea is if I disclose to you, rightfully to your point, that generative AI was used, what are the limits of my consent on that? And specifically, is it certain types of uses that I agree to? And kind of how broad should I kind of say, like, I've used generative AI? Is it that I've used generative AI from the research process to the drafting all the way to the review? And that's enough for me to share? Or is it that certain clauses I have to get down to that granular level? And that's the type of disclosure that we're looking for. And truth be told, it's really hard to say at this point because, from a kind of sandboxing or deployment or real production deployment in business right now, we don't have any metrics or any sort of statistics right now on actually what is
Right.
the extent of end use. There's still quite a few law firms, I think, that are just experimenting with what works best for their law firm. And I think until we have a certain level of almost understanding around what are agreed upon use cases. For example, if all law firms decide that generative AI is going to be used for legal research, then I'm not necessarily sure that disclosure might be needed at that point, since it's a consensus and a standard now, or sort of a standard that's used across the industry. But if there is still kind of a variation on, how far I have to review my contracts, both as a human versus as a machine, that's the type of disclosure that I might be a little bit more sensitive to. And so I think that it's quite hard to say at this point, this is how much I want disclosed to me, and this is how I'll accept in terms of from a consent perspective. But all I can say is we have to kind of see, at an industry level, kind of what people feel is the best use case at this point. And it's hard to say because a lot of law firms, even at this stage, haven't quite been super, I think, forward about what their use cases actually are in practice. There's only a lot of perceived uses, but not enough actual declarations of actual use.
Yeah, that I think is that's a state everywhere in other industries as well. So it's really interesting to hear that. I just fear, Megan, that disclosure is not enough, right? It's not enough for me to know that yes, they are using generative AI, but what impact it has, how do you de-risk that? That is a not solved for, to your point. And I agree that it's not trivial. This
Yeah.
is something we have to think about,
Yeah, that's a
and
very
each context driven, right?
Absolutely. I mean, I think you are spot on to say, disclosures alone, they're almost like disclaimers that we see everywhere. You'll see them kind of, when you eat unhealthy food, for example, is it enough to kind of deter me? I'm not sure. But what we're thinking about, at least in our research center, the other side of it, we're working very closely with a law firm, international law firm DLA Piper, who's been at the forefront of understanding these technologies. And we're trying to kind of put together what we see as a toolkit. So
Okay.
if I was a company that decided that I would adopt generative AI, um, do you have the right guardrails is something that we always talk about. Is it so, in addition to sort of using techniques like RAG, and kind of fine tuning sort of on your own data, is there kind of way for you to curb the actual output? so that they're consistent with stakeholder obligations in addition to legal
Mhm.
obligations. The other toolkit that we're thinking about is companies such as Arise AI. They've been thinking a lot about LLM monitoring and LLM observability. So once you put an LLM into production or a large language model into production, you know, how often are you observing that the outputs are consistent with the range that you've specified? And what causes sort of a deviation from those outputs? And that's a sort of continuous monitoring cycle. And so we're really kind of interested in addition to disclosure, then, are there practical tools that these companies are ensuring are in place? And how do we advocate for this infrastructure across the board?
Yes, thank you. And that very, very closely aligns with, my area of focus too, which is auditing, right? One of the pillars, so the trusted AI pillars, I'm referring to them, maybe I should just describe them too, is security and privacy as a foundation. But there are also six other pillars, which is transparency, explainability, audit, regulations, and freedom from bias, so ethics. So I hope I covered them all. But the main thing that I want to mention here is one thing everybody should be aware of is audit. The role of audit and what you're defining as continuous monitoring and monitoring the performance, that's what I'm looking at as auditing in the AI world. It's not enough to kind of just monitor, from and do an audit at a month's frequency of a month, or whatever that might frequency might be for you, for a company. But when it comes to auditing AI, it's going to be in a more continuous fashion. Risk and governance is something that has to be kind of integrated and looked at in a more continuous fashion. And that's that. If there is nothing else, I think that's the point I would highlight, animate, that risk management is very different for AI, and technology adoption is it's really important to have that de-risking in the mindset as you're examining that. So this is fantastic. I really learned a lot from your description of what you're doing and how the it's fantastic that the ABA in California adopted your guidelines also from coming from the responsible output. Is there anything you'd like to share as a conclusion for the audience?
Yeah, so I mean, I always say this, I think, in some of the other discussions I've had, but I think part of the de risking process and risk mitigation process also comes by also holding yourself to a sense of slight bravery where you should test out the tools to an extent. And um, I say, don't be afraid to get your hands a little dirty at times, and be a little creative as well. I think a lot of these tools have an immense creative capability that we're not necessarily tapping into just yet. I think our focus on kind of using them for search reasons, for accuracy reasons, that's where these risks are coming up. And so, why don't we kind of think more seriously about the technical architecture and say, can we leverage this technical architecture for other more fluid, narrative driven uses? And then maybe kind of our risk understanding will shift and find other ways to de risk. And so, I just want to also say that I appreciate so much the work that you're doing. I think it's more important than ever to have
Oh, thank
people
you.
kind of bear the cross of AI governance, AI responsibility, and ethics, and kind of showing what trust looks like. I know a lot of people are thinking about what it means to trust machines in this era. So your work is just incredible that you're kind of spearheading this.
Oh my God, thank you so much, Megan. That means so much to me. Thank you. And thanks for everything. Even the conversations we had in preparation for the podcast, when you shared how your work is influencing us as consumers, as we are going to rent a car, for example, the example you gave. I think maybe if you want to just even share that for the audience before we conclude, that would be amazing.
Yeah. So actually, another side of one of our flagship projects with Codex is about how do you make existing sort of contracts more accessible to everyone. And so, in addition to generative AI, we have a huge focus on good old fashioned AI or symbolic approaches that use expert systems. And so, for us, we have something called computable contracts. And so, the scenario we always give is if you're standing in front of Hertz to rent a car, they're always trying to sell you rental car insurance, but you're never fully certain. You kind of take a gamble at times, but whether you buy it or you don't. And what we're believing here and what we stand kind of on this sort of expert system side is if you formalize a contract, then you can do kind of very sort of high level analytical approaches so that you can compare with certainty on your existing portfolio of insurance whether or not your rental car insurance actually is needed or it's not. And so, what we often say is that actually your existing set of contracts, such as your credit card insurance, your travel insurance, or your automobile insurance, they usually kind of sufficiently cover most insurance scenarios, most collision damage. But there are times where it might not be the case. For example, if you are going to Ireland. And so, in that case, you might actually need to buy rental car insurance. But you can say with definite certainty if you're able to translate these contracts into a computable logic form. So that's the other side of it. And I think kind of tying it back to questions about generative AI and risk. Well, I always say that I don't think we should totally forget about these other technologies that have existed for a while. One of the ways that we can actually de risk is think about what is the kind of division of labor that we should see across our machines. Some tasks are more accuracy driven, so we might want to go back to expert systems. Some other tasks are more creative and narrative, and we need to process data in large amounts. And so we might turn to, neural systems such as natural language processing or large language models. But being able to kind of make the assessment on what strengths from what technology and how to use them, that's something that we need to be thinking more seriously when we want to kind of consider risk mitigation.
Wow. Thank you. I am actually speechless for a change. That is a brilliant way of summing it up, and I appreciate it. Thank you.
Thank you.